Hello, everybody. Chuck Cook here from Impact Litigation. Got our ever handsome Greg Tiskin and the adorable Aaron Hall with us tonight. Chuck is on vacation this week. Will not be joining us. What did he call it? A part-time vacation? Is that what he's going to be doing? So we just want to jump right into it. There's just not a lot of news this week. Just a little bit, but not a super lot. Greg, I'm going to ask you to talk about the big news today from the White House, or the leak from the White House, the intentional leak.
Yeah, so we're learning mostly from the news media what this plan is, but so it's good news. The White House is doing what we have suggested forever that they do, which is change the travel ban to instead of an outright ban that has no strategy involved with it, to have something that's actually healthcare related and have a vaccine/testing regimen to allow people to enter who can demonstrate that they pose no health threat to the United States, which was what these whole travel bans are supposed to be about. So we're told that through these leaks that this is going to happen in November. And it apparently is for all the countries. So that's all good. We don't know, I guess, exactly when. We don't know what kind of exceptions are built in for people. For example, if you're in a country where a vaccine is not so easy to get. We don't know whether they are still going to be doing national interest exceptions anymore for people that are not able to be vaccinated for one reason or another. We don't know anything on there. And so consequently, Chuck, the questions that have been popping up today on my Twitter feed are, what does this mean for our Kinsley litigation? And I think for right now, Kinsley, first of all, we don't have a policy. You can't just basically...
the New York Times does not set policy. Is that?
Well, look, let's think of this like the booster shot. Remember when the president said a couple weeks ago, everybody's getting a booster shot on September 20th?
Yeah.
And
wait a second, that's today.
Yeah. Well, did you get your booster?
No. Aaron, did you get your booster? I didn't get mine.
Right. So the president can make an announcement, and a lot of things can happen along the way that it doesn't actually happen. And that's a good one, because the FDA basically told him it ain't happening on there. So we don't have booster shots. So, I mean, just because the president leaks something to the New York Times doesn't make it so. Even if he honestly is telling you what his intentions are, there's a long time between now and November, and there's a lot of things that could happen. So it's good news.
Greg, but I think they're actually going to have lawyers look at it this time.
Yeah.
So they don't get sued a billion times and lose a billion times on the same issue. And hopefully somebody will advise the State Department that they have to issue the damn visas again. So there will be, what is it? A travel ban no more forever, or something like that. To quote a.
Yeah. Well, so we will see where that's going. In the meantime, in our Kinsley case, God, I wish the judge would just get to this. And I mean, I don't know what else he needs or what, but anyway. Hopefully he'll make a decision shortly. He's reading news as well. I have a feeling that's bad. I think it's potentially not good news for us if it gives the judge an excuse to just sit on this decision so long.
Yeah, which is what, as you noted earlier in our pre-discussion, it's what happened in the Annunziato case.
Yeah.
Judge was all set to rule, and he just waited after the election to see what Biden would do, and then just dismissed the case as soon as Biden decided that he was going to change the travel bans and lift the bars. And so, we don't know. We just don't know. So the answer to that question is we don't know. So that's the travel ban / really the Kinsley case. And I put the travel ban word up, but I didn't write Kinsley, but that's kind of what it is.
Right.
Let's look at some of the other cases here, because people are asking about the Go case. We have a status report due, right, Aaron, on Friday.
And then Wednesday
conference call with the judge on Monday, the 27th.
Right.
Is that right?
No, it is the 27th. I just can't remember what day of the week.
It's the 27th. And then we don't have a call-in information or anything about the 27th, but we'll have a call with the judge. The judge instructed the government to file a joint report with us, but also the government to estimate how many more visas they will do between the 27th and the 30th.
There was some information that got sent from the government lawyer in the other case, in the Curtis's case, that was, is potentially applicable to our plaintiffs.
But it was very vague. It was just a reiteration of the stuff that we already knew, which was three different consulates said they could take some extra people.
Yeah.
That's it. I mean, it wasn't what we all asked for. We have not been answered, right, Aaron? We have got no answer from the government lawyer. I'm sure you'll send out a reminder before we're done tonight to Joe and say,
at least Curtis got an answer on his
we didn't get an answer. And part of that was, I think part of that though was because they had a status hearing.
Yeah.
And I think there was some pressure there to get some answer in, whereas ours doesn't, ours is until Friday, our status report. But please, all Go plaintiffs, please update the form. We had several people today get their visas. Congratulations to you. At least one of them was a third country visa interview that had to get done. So keep updating us on that so we can report to the judge what we know about our plaintiffs when the government reports about what they know about our plaintiffs. And hopefully that's the same thing. Aaron, anything to add on the Go stuff at this point?
No, we're all getting a lot of emails saying, what happens when there's a reservation? How long is it going to take to process any reserved visas? We don't know. We won't know until there's an order. The other question we're getting is, because Go is summary judgment, does that mean Go plaintiffs start getting their visas out of that pool before plaintiffs from other cases who are still going to be awaiting this final decision? It could be, but the judge has a lot of leeway on how he crafts any order, and so I don't want to tell you that that's going to happen. We're happy that we are at the summary judgment phase. We think it gives our plaintiffs the best chance, but we'll have to see what the judge does.
Of getting those reserve visas. Keep in mind the Gomez people just got their summary judgment a couple weeks ago, and the department said, well, we'll process them in 2023. We're still waiting for the Gomez people, by the way. Still waiting on the judge on that issue. But I mean, is the department, when they lose this finally and get reservations, tell us we can't do these till 2024? I mean, I don't know. So at this point, it's just a question of get as many done as you possibly can now. Do what you can to get appointments. Some consulates are telling people, well, we can't schedule you. Only KCC can do that. We know that's not true because a lot of consulates have just called people without the KCC scheduling them. It's at Montreal, that's not true. And so that's kind of where we are on both those cases. We got
some bad news regarding Congress coming to the rescue on the DV folks. Today, and I don't know if you want me to mention anything about.
Let's talk about this bill.
There was a section in this bill on the House side that basically said all unused DV numbers for people that were not able to get appointments because of bans or travel bans or Muslim bans on there, that they would, the numbers that were not used up from 2017 through the most recent year, that those numbers would effectively all be reserved or all, and people could apply well after the deadlines for those. And that was, obviously would be wonderful if that happened. And there's a lot of other important things that are in that bill that deal with, especially like our Chakrabarty folks. There's a lot of provisions in there that allow people to get around country quotas and all kinds of other things that are in there. So this is all incorporated into this reconciliation bill. And the main thing to know about that is it's a massive budget and finance bill that normally the Democrats have to get 60 votes to pass legislation because of this thing called the filibuster. they can do it with 50 votes for this special kind of bill called a reconciliation bill. They are trying to put immigration in that bill. And there's this person who's like the referee in the Senate called the parliamentarian who can decide whether something should properly be in this reconciliation bill if it's about the budget and finance. She had.
Oh, Greg, remind, it's a made-up job with no basis in law or the Constitution.
No, yeah. So it's sort of a it's kind of a shadowy kind of job. But anyway, she had to make a decision on whether she was going to let the immigration stuff be included in this reconciliation bill. She can be overruled potentially, or she could be fired. But she has indicated that she is not comfortable with the stuff that they sent her. Now, they had only presented her.
Is that the word she said, Greg? Is that the word she used?
What's that?
You are being too kind to a former immigration deportation attorney.
Yeah, no, she gave a lot of gobbledygook in this opinion where she said it was not political, even though it was all political. But here's the reason why you shouldn't give up hope on there. First of all, they knew this was a possibility of the Democrats when they did this. So they only gave her a piece of the House bill, basically to kind of test the waters. The most controversial part they gave her, figuring that if that would work, then everything else should fly. That was the most controversial piece. And the alternative, I mean, basically what they knew is that if she said no, they had a different approach that they could take and see if they can get a different answer out of her doing it another way, which wasn't the preferred way, but this is the other way, which is two parts to it. One is updating the registry date. Now, a registry is a program none of you have probably heard of unless you're really on immigration Twitter all the time. But it's because nobody has been qualified to apply for this program for decades.
Oh, no, Greg. I did a registry case 5 years ago.
Right.
So,
but I saw the statistics. I posted an article that forward.us had about the registry today. It's a really good article if you go on my Twitter feed, if you really want to understand what this thing is. And the registry it was a program that was created in 1929. And it's always said that basically if you could show that it's a cleanup program. So for people that there was considered a good policy reasons why you don't want people to be in the U.S. for years and years and years and not be able to get any kind of status. They don't want basically to have sort of this shadow population, which is like what we have on there. So 100 years ago, Congress was thinking that's not the greatest of ideas. And so the initial registry said that in 1929, if you were here before 1921, that we would let you get a green card and you can proceed on to citizenship 5 years later.
And by the way, that was at the height of nativism in our history.
Yeah. So that date has been updated over the generations. And the last time it was updated was in 1987 as part of the big immigration reform bill that year, where they moved it up. I forget what it was before, but they moved the registry all the way up to 1972. So it was only 15 years before at that point. And that is what the plan is to change the date from January 1st, 1972 to, I don't know what the date that they're planning on. I've seen different people throwing out different dates. And it shouldn't really matter because if she buys one date, she should buy any date. But on there, but that's the big unknown is like what date they're going to go up to, and that's how they're going to deal with the legalization piece. The good news is the rest of the stuff that was in the House bill that people are having a big freak out on Twitter that why wasn't this stuff included with what was sent to the parliamentarian? Surely you have it in for all this.
It's all a conspiracy.
It had nothing to do with what the strategy was. And I have told people that stop attacking Senator Durbin. This is not about trying to screw over skilled workers, and it never was. And this, I think, it's kind of proven out that was probably the smart strategy. But anyway, those provisions are very much in the conversation with what's going to be presented next to the parliamentarian, and we will see what she has to say after that. Now, if she says no again, then we'll see. Then they're going to have to make some tough choices.
We might have to call Amazon and order a backbone for Democrats. That might be required. All right.
So hopefully, fingers crossed.
All right. As on all of our K1 litigation, except for King, in which we're responding to a motion to dismiss tomorrow, we don't have any news. Milligan, Rio, Manila, Moscow. We got nothing. We're just literally waiting for all these judges to make a decision. And somebody asked earlier, I saw, can you file a mandamus against the judge to make a decision? The answer is no, you cannot do that.
I wish.
File a mandamus against an immigration judge, but not against a federal court judge on that case. So
we might have to come up with some reasons to send supplemental things just to kind of remind the judge that we're still waiting.
We don't really have anything to send that's super helpful at this point, but there was a really good decision that came out in the 42B. I mean, in the Title 42, sending people back to Mexico for COVID issues, and the judge there really said some really great stuff. And so we're going to look at sending that in to them because the same district as all our cases, and it really talks about this idea that you can just take as long as you want because of COVID without making no mitigation efforts is unreasonable, is inherently unreasonable.
Yeah.
So we're gonna do some stuff on that this week, and hopefully get something in. Aaron, we talk about the Chakrabarty litigation. We filed our response to the government, our reply to the government response on the motion for preliminary injunction, and our response to the change of venue motion that they filed for this. What can fill us in on where we are on that?
Yeah, so that was submitted on Friday. And you're right. There's kind of two parts to it. The first is the government's request to transfer venue and sever all the cases. The judge obviously signaled that he was inclined to agree with to do that. But I hope that he's reading the briefing with an open mind because it doesn't make any sense to sever the cases or transfer venue. It makes zero sense. It's in nobody's interest, including the government attorneys. It's in nobody's interest to do this. The case is ready to be. It's ripe for a decision on a preliminary injunction, and they didn't spend a lot of time actually responding to our request for a preliminary injunction.
They did not, did they?
And they didn't go through. They didn't spend time going through the track factors. And really, anything that's not argued by them should be deemed waived by the judge, and the judge should be entering a preliminary injunction. Now, as well as I do, everybody listening, that he hasn't handled that case in that manner so far, and so we now just have to wait and see what he decides to do. So I'm looking forward to the decision because I really don't think you can justify getting rid of this case by transferring it.
Everybody. And, when the government responded, they said in there, well, here's where everybody is. Over half our plaintiffs were in the National Benefits Center, which does not adjudicate cases on adjustment of status for employment. They don't. So our cases were essentially in a limbo land. You can't sue the Nebraska Service Center because, the National Benefits Center, because they don't adjudicate cases. So you can only sue 35 different offices around the country? That makes no sense whatsoever. No. Yeah,
we're looking at our options. We're not going to tell on a public, this is on YouTube and it's more for the government lawyers to review. So we're not going to go through our specifics as far as what we'll do with if this happens or that happens.
We have a plan.
We are, so rest assured that we have contingency arrangements, just like the government, just like Plan B and Plan C for the Congress.
That's right. Next thing is just to let you know, Aaron and Jeff are filing tonight the wage rule litigation. This is actually working with Ayla on this. A judge has already stopped this rule, but only because of the what is that clause? The appointments clause. He didn't address the merits of the case. So we're filing on the merits of the case in DC. That's getting filed. That's on the how you determine wages. You get paid more, you get a higher chance of getting your H-1B. We're fighting that.
At some point, the government's going to they're going to have to figure out how to get out.
Cut bait on this. I cannot believe the Biden administration is still supporting this. Boggles the mind.
It's such a loser for them.
It is a loser. H-1B lottery abuse case. We are responding now to the government on that. That'll be due on Thursday. We're going to get it in by Friday, but the goal is to get it in Wednesday. If, again, we did talk to an employer and haven't heard back. If one of you plaintiffs have an employer, that would be very helpful in our response to the motion to dismiss on that case. But I feel good about the motion to dismiss. I mean, in reality, we have a declaration. Their motion to dismiss was very. It wasn't
no cost for an employer that wants to join.
For free. I mean, just a question. We see in the body would be very nice. All right. And even just a declaration at this point, because we're not amending the complaint. So really it's just a declaration at this point, which we already have from, one employer. So we're good there. Other than that, we do have the EAD sign-up case. We're still taking plaintiffs on. This is a fight on the EAD program. So if you're waiting on your EAD for 11 months, sign up. That's what they're here for. I don't have anything else here that I want to touch, so we're going to go right to the questions. We want to this is a shortened version. We all have a little bit of commitments. We're not going to be here until 7, so it won't be too late. Elon, we talked about the K1 cases. We have no update. We're just kind of waiting. The final judgment in summary judgment will be by the end of September. That's going to be final summary judgment. So, Aaron, do you disagree with that?
Nope. No, that's my expectation.
I don't know when Gomez will be, but we'll get that final judgment. When we file an emergency appeal, will that do the same judge, dates retrogress cases? Oh, Venkat must be talking about the EB AOS delay case.
Chakrabarty, yeah, sure.
He will not be filing an appeal emergency because the Fourth Circuit does not allow for appeals of the change of venue motion on an interlocutory basis. So we have a different plan to move forward on, and we will update you guys separately on that should that happen. Why are we not responding to the main point of the government? They can't get priority. That's a non-existent point. Everybody gets priority. And we know, and we gave them evidence that they are adjudicating people that filed after our clients and before our clients. They have no order. Aaron, do they have any order in which they adjudicate cases?
No, the other point on this is what they say in every mandamus case, but actually Chakrabarty is a little bit different because we're part of the relief that we're asking for is the reservation of visas. That's to benefit everybody. It's not that 196 people are jumping over everybody else. You give us the relief that we want, and everybody benefits. So the judge need not worry about that.
Yeah, at that point, the mandamus goes away because they're reserved. Everybody's going to get their visas. And what we learned, of course, from the most recent visa bulletin was and their own testimony. They're going to leave 85, 90,000 visas on the table. And they have no plan to get them done. And next year, we don't know how many family cases are coming over. So they might not be 100,000 or it might be 50. We just don't know, which is weird because we knew last October when the visa bulletin came out. And this year, they're being a lot more cautious because they know they're going to get sued on this. It's crazy stuff. Thank you, Venkat. You'll remember, you only have to ask a question once. We don't skip people, okay? Mike, I know Mike's a good guy. He emails us a lot. This just totally sucks. Somebody just got an email back today that the National Visa Center had approved an expedite in Manila, sent an email to Manila. Manila said, no, we're not going to. It's just bananas. It's just the whole thing's bananas. Let's see. You guys lost it. I don't know who Tim Price is, but we didn't lose anything. I feel very confident we're going to win that H-1B lottery case. Advice for Go plaintiffs at the time we didn't receive the employment. Again, we've said this. Greg, how many times should you email the KCC and the consulate? What would you be doing if it was you?
I mean, I would be doing everything I could right now to get him to, but I don't know how many that.
I'd be emailing every day. The wheel gets the grease. We have one plaintiff that got an interview
You don't have to copy us on your emails.
No, don't copy it. But he was a squeaky wheel, and they just called him in and said, "Get in here." Be the squeaky wheel. It worked in Gomez last year. I can tell you that.
Yeah.
Is it possible the judge will reserve visas for only Go plaintiffs? No. The judge has to reserve visas for everybody. He may separate out. He might say, well, Go, how many people got approved? Okay, you need 800 visas. You need 600 visas. I reserve 600 visas. So that's what I think will likely happen. Aaron, do you think that's wrong? I don't think he's going to reserve an incredible number. I think he's going to reserve them for our plaintiffs at this point.
Yeah, I don't have a sense of it. I mean, I think he could do that. He could just pick a number that he calculates and then say, this is to be distributed amongst the plaintiffs in the various lawsuits, not guaranteeing that everybody will get theirs. We don't know.
Yeah.
Ram, we already told you our strategy to win this case. It's a really good strategy, and we'll see what the judge does. And justice would require that he have an oral argument in which we can actually present argument. That would be good, because he still is not. I mean, what he has done so far is really beyond the pale. Really beyond the pale. Let's see. Go September 15th document qualified interview. Oh, there you go. Congratulations. See? That does work. It does work. If the judge says 3 to 5 years, well, that's just outrageous. And K-1 petitions can basically, the consulate has the authority under the FAM just to keep renewing the K-1. They can just keep renewing it. So it's never going to expire. Oh, Greg, we've got to talk about this. Today, we discovered, and all the lawyers discovered, that the Immigration Service had quietly changed their policy on the 90-day fraud rule. So basically, Department of State under Trump said, if you enter the country on a visitor visa and within 90 days file a change of status or adjustment of status, we, the Department of State, will consider you to have committed fraud. All right, got that. Immigration had done some little policy change and said, hey, 90-day rule. But today they announced they removed everything about a 90-day rule from their own internal guidance and policies. So somebody enters the country on a visa waiver and they get married after 30, 45 days. I mean, I would wait at least 30, okay? But 60, adjust your status. So if you're on a K-1, and again, all of us have talked about this before, we generally, in most circumstances, tell clients not to do a K-1, generally, because it's just an added expense that you're going to have to go through. It generally doesn't get your spouse here any faster. And as we've learned in COVID, there are some of our clients that had a K-1, joined the lawsuit, decided to go over and get married, file the petition, and are in the process of waiting for their interview at the consulate.
I think you have to be careful and still probably talk to counsel before that, just because even without this 90-day rule, first of all, if you are coming in as a visitor and you show up at a port of entry with CBP officer and they think you're coming in to get married and immediately file for a green card, you could still get slapped with fraud finding there if they kind of get it, if they go through your luggage and they find all this stuff contrary to that. So I'm not so sure that still, that's anything goes on that. But I would, it is good news for sure. But I'm not as well.
I have been telling people don't do anything for 90 days. That's no longer the case. Now you have to use your best judgment. I would say 60 days is a safe harbor. It always was previously. But that's great news for case.
If your plans genuinely change, you don't have to wait 90 days before announcing those plans or doing what you're going to do, I think. Right. But you still have to have whatever your intentions were when you're coming to the United States. That has to be genuine, and you have to genuinely not be planning to marry when you're coming into the United States.
I agree. But if you happen to change your mind, you don't need to wait 90 days to change your mind. That's what I'm saying.
Right. That's what's changed.
All right. So no K-1 should take longer than a few months at the consulate. That it's taken this long for people is just it can't de facto be reasonable, because you can get on an airplane, go over there, get married, file an I-130, and then get a priority interview at the consulate and come in. I mean, it doesn't make any sense. The whole system doesn't make any sense.
You're gonna have to pick a good representative, a couple of questions to wrap it up, because Aaron and Aaron have to go.
We're getting there. Aaron's got to go. Just this one, Aaron. Is there a possibility the Go plans will not benefit from? I see no circumstances under which that happens. No,
I don't think so.
No, I see no circumstances under which that happens. Let's see. Medicals. Lots of us have doubts about getting medicals. Look, if you've got an interview coming up, you should get a medical exam. And some people can't get into medicals. This is, again, why reservation is so important. But do what you can. I mean, beg the doctor.
I know it's expensive to do it and pain in the neck, but I would be as ready as possible to get it. If they announced that you had an interview tomorrow, that you had everything ready to go.
Yeah, Patrick, you are right. No judge said that. Would that be reasonable? If we could only find a judge. We actually had an immigration judge here in Atlanta who actually used the K-1 visa to get his spouse. So, I mean, that's how it happens. Sonny talked about Kimungs earlier, that when ultimately we get an adjudication in this, obviously the idea is everybody's adjudicated in fiscal year 2022. Muslim banned people should be eligible under the reserved Go visas, which are, quote, random. You should be eligible, okay? Let's see. And yes, Sonny, we know EB3 retrogression is, they're talking about it. The director talked. I don't see how that's going to happen, honestly, with the numbers. But actually, you know what, Greg? I take that back. They have 280,000 pending cases right now. If, they're going to get 90,000 are gone, going to get 140, they're not going to get 100,000. So they still won't get to 280. So actually, I could see a retrogression. I could see that happening now that we've seen their actual numbers and they have shown their hand. Let's see. What 3 consulates took more people? One was Jordan. One was. Remember, Aaron? One was Jordan. Poland, Warsaw. Warsaw was the second. And can't remember the third. Let's see. Let's see. Montreal processed 38 Go cases today. Awesome. Woo! That's awesome.
No, it just Montreal has processed 38 cases. I don't know if they were all Go.
Well, I think today they had 50 people scheduled for today.
Oh, okay.
So they had a bunch scheduled there. I didn't know Canada was a diversity visa country.
Well, there's a lot of landed immigrants in Canada.
Oh, that's probably why. Okay, that's probably why. Let's see. We don't have any update from Barry, do we? We haven't heard from Barry in this case.
No, I'll check in with him.
Checking out. Okay. Danielle, if Go plaintiffs in their mandamus get expedited, help our case in the sense that K1 cases are supposed to have much higher priority in processing than DV cases. Well, we think the judge tossed out the entire prioritization process. Isn't that right, Aaron? That's the way I read his decision. But
he tossed it out as it pertains to DV.
Yeah.
People.
Yeah. Okay.
Right. You can't prioritize one type of case over another. There's other ways that you can still prioritize.
I do think it's a good idea to join the EAD litigation if you're in any case, including Chakrabarty, because we just don't know when they're going to get the stuff. Okay.
Yeah.
If you're not vaccinated because vaccine is unavailable in your country, is that a problem for getting a case through or getting an interview? No, not for an EB case, not for a DV case, not for a K1 case. What it does mean is you might have to quarantine in a third country for 14 days. We don't know what the ultimate policy will be. Okay. So let's take the Terry Wong. I mean, judge to reserve a visa tomorrow's fast. They go for medical. AP depends on the consulate. We just don't know. Every consulate's different. How long does the medical exam take? How long does the blood work take? I don't know. Every consulate's different. So we'll go. Good luck with that. All right, everybody. We're done for tonight. Aaron's got to pick up his kids. Greg's got to go on a long bike ride before it gets dark. And I want to eat dinner. We'll talk to you guys next week. Greg, you'll be here tomorrow?
Yeah, tomorrow I'll be in my usual time, 1 Central.
I'll be Wednesday at 2 Eastern. Aaron on Thursday.
We're Thursday at 2 Eastern.
Thursday at 2, and Friday we're here as well. All right, everybody, have a great week. We'll talk to you then. Bye-bye.
Be well.